Mr. Schwartz. Thank you.
Thank you, Lord Hodge. Before the break, I was discussing the submissions around the context in the treaty and the language in Article 7 and Article 14 relating to the carrying on of activities, and how that helps explain the context, even if one were to take a narrow view of the effect of the deeming in section 15 sub 2. And perhaps just to emphasize the point, if I can refer you to the OECD commentary on Article 15 of the model, that's at tab 36 and page 714 in the new bundle. This is the commentary on paragraph 1. The first sentence says, paragraph 1 establishes the general rule as to the taxation from employment other than pensions, namely that such income is taxable in the state where employment is actually exercised. And then 2 lines down, it continues, employment is exercised in the place where the employee is physically present when performing the activities for which the employment is paid. And so that tells you that it is the exercise of activities that is really the important connecting factor. And that language has been in the OECD commentary since its inception with the 1963 model. If you turn to page 742 of the bundle, it's page C15-29 of the commentary. There it sets out the history of the commentary, and you can see the history to paragraph 1 starts at the bottom of that page, and over to page 743, you can see that in each stage it has contained exactly that same text. So that has been the consistent position. And so the question, of course, is the deeming limited, as my learned friend says, to the carrying on of the trade? And if one looks at the wording there, the performance of duties of employment is instead treated for income tax purposes as the carrying on of a trade in the United Kingdom. The natural conclusion that one would reach, putting all of that together, is that if you are treated as carrying on trade activities, then actually that is carrying on a trade for income tax purposes. And that is consistent with the purpose which we say, which is to put all divers, whether employed contractually or self-employed, on an equal footing. And if one is applying the criteria that were set out in the Metrolands case and endorsed in DCC Holdings, in other words, looking at whether the application of the provision would lead to an unjust, anomalous, or absurd result. As far as the justice of the result is concerned, that would achieve the justice of the result because it would treat those parties that are intended to be treated equally on that basis, and it would be unjust to treat them any differently. If one sticks with those criteria, would it be anomalous? My learned friend referred to the fact that the scope of the deeming is limited to seabed activities, which he says is anomalous because 2 divers doing different things would have different treatment. Well, firstly, that is the intention of the statute in focusing the deeming provision narrowly. And secondly, it is not something which is drawn from the real world. The HMRC opening paragraphs of their case and their grounds of appeal say that Mr. Fowler is a saturation diver. And that is not explained, but saturation divers are so called because they work at great depth on the seabed. It's called saturation diving because they have the maximum amount of nitrogen in their blood that the human body can tolerate. And they work for long periods and live in that state of saturation throughout their particular engagement. And when it is concluded, they then decompress slowly in order to avoid the bends, which is the common name for decompression sickness. So the hypothesis that a diver could be acting under a single contract, working on the seabed in that manner, and under the same contract, perhaps scraping barnacles off the bottom of a fishing boat in Aberdeen Harbour, is just not connected with anything that is going to actually occur. And so in terms of anomaly, that points in the direction of the taxpayers' interpretation. The extent of the deeming is also explicit. It is for income tax purposes. And as we have said, for income tax purposes, it covers all three of the relevant pieces of legislation that are now in the rewrite covering income tax. In other words, ITOIA, ITEPA, and TIOPA, which deals with the incorporation of treaties into domestic law. The Marshall and Carr, again referred to in DCC Holdings, requires that we are to determine the consequences and incidents that flow from the deeming. And if we have a look at those, the natural consequences, if we are deemed for income tax purposes, is that in every respect, the result of a diver carrying on a trade applies for income tax purposes. And there is a distinction, of course, between the effect of the deeming, which is the diver carrying on a trade, and the consequences which flow from that. And in order to make sense of the legislation as a whole, one does need to look at that. And this really brings us to the function of section 6 sub 5 of ITEPA. So that is the provision that excludes this particular income from the charge under those provisions. And that is in the first bundle behind tab 7. And it's on page 207. Employment income is not charged to tax under this part if it is within the charge to tax under Part 2 of ITOIA trading income by virtue of Section 15 of that Act. And what that makes clear is that the provisions of Section 6 sub 5 are consequential on the deeming which is set out in Section 15 sub 2 of ITOIA. And one of the traps, perhaps, that my learned friend and Lord Justice Lewison have fallen into is just taking an iterative approach to the legislation, working through, perhaps in what would appear to be chronological order, the provisions, because that actually produces the wrong result. And in addition to that, it doesn't give effect to the need to construe the provisions of section 15 in a way which is consistent with the predecessor legislation. If you look at the way that it is set out both in the case of HMRC and in the decision of Lord Justice Lewison, they start by either describing or reciting section 6 sub 5 and then section 15 of Itoya. And to put this into context, perhaps if I can refer to what Lady Arden said about the rewrite legislation in the Derry case, that it does function in some respects as consolidation legislation, but it is not typical consolidation legislation. And in this particular instance, there is a different function of the rewrite legislation, and that is it is dismembering legislation. In other words, it dismembers the predecessor provision, section 314 rather, of ICTA. It cuts it up and it puts it in two different places. And if you view them independently, as my learned friend has, it results in doing exactly what he has done, which is to put undue and unjustified weight on section 6 sub 5 as an independent provision. In fact, what section 6 sub 5 is, and this is the same in the predecessor, which I will take you to in a minute, is it simply sets out in express terms what are the consequences and incidents flowing from the deeming. And the references in section 6 sub 5 to employment income is actually employment income that would be employment income but for the deeming in section 15 sub 2 of Itoya. In other words, it would frustrate the effect of the deeming if you were to simply say that it's the same old unchanged employment income. You'd have to ignore the effect of the deeming to come to that conclusion, because the income that flows from carrying on the activities of a trade is a receipt of that trade. It is no longer the employment income. That is a natural consequence which must inevitably flow from deeming the activities to be a trade. And that is also consistent with the conclusion that it is for income tax purposes. And if one looks at the predecessor legislation, which is behind tab 5, it's page 199 of the new bundle, then it's absolutely clear that what is now section 6 sub 5 of ITEPA is a consequence of the deeming. So the first part of it is pretty much the same as section 15 sub 1. It's the full paragraph which says the Income Tax Acts shall have effect as if the performance by that person of those duties, in other words, the subject of the deeming, constituted the carrying on by him of a trade. So the rewrite has tracked that legislation entirely. It then adds in for elaboration within case 1 of Schedule D, makes it abundantly clear that the consequence of carrying on a trade is the inclusion in case 1 of Schedule D. And if you look at tab 5, or rather tab 4, where the schedules are described, Schedule D is on page 195 of the new bundle. This is section 18.9 sub 1. It's also in various places. A(3), to any person, although not resident in the United Kingdom, from any trade, profession, or vocation exercised, again, exercised, carried out in the United Kingdom. And case 1 below is tax in respect of any trade carried on in the United Kingdom. So it explains explicitly a consequence and incident flowing from the deeming. And it's followed by a semicolon, and accordingly, Schedule E shall not apply to the emoluments from the employment so far as attributable to his performance of those duties. Now, again, the wording that follows, emphasized by the word accordingly, makes it clear that this is an explicit statement of the consequences and incidents flowing from the deeming. And for the same reason, the reference to emoluments from the employment again refer to the emoluments from the employment that would exist but do not because of the deeming in the previous part of the section. And the language is perhaps even stronger in the predecessor in excluding income treatment, because it says Schedule E shall not apply. And if one goes back to Schedule E, which is on page 196, in the middle of the page, the tax under this schedule shall be charged in respect of any office or employment on emoluments therefrom which fall under one or more of the following cases. So it's completely excluded from that. And it's only when you look at the predecessor that you realize that you've got to look at the two together. You cannot fall victim to the separation that takes place when the rewrite places this in different legislation. And if one were to look at section 15 by itself, the performance of duties is instead treated for income tax purposes as the carrying on of a trade. If there was nothing more, one would still come to the conclusion that because it is treated for income tax purposes as the carrying on of a trade, it cannot be an employment, and it cannot be taxed as income under what is now the employment income parts of ITEPA. But because it is in separate legislation, it's necessary to say something very explicit about that. And in addition, the author of the rewrite has been careful to try to track the language as closely as possible. And so we have a slightly different wording of the same thing, but it is the expression by virtue of that tells us that the exclusion from employment treated is because it is already deemed to be a trade by reason of the operative deeming provision, which is section 15 sub 2. This deeming, of course, does not extend beyond the stated statutory purpose, which is income tax. And therefore, all those other issues to which the definition might apply are simply irrelevant. It doesn't attempt to reclassify the contract as a contract for services. From a contractual point of view or for any other purpose, that relationship will continue to be governed by whatever law governs it. But as far as employment is concerned, it is deemed to be a carrying on of a trade.
I think you mean for the purpose of tax, it's deemed to be a carrying on of the trade, not for the purposes of employment.
For the purpose of tax, thank you, my lord. It is for income tax. It is narrowly confined just to that. So for another tax, it would not be. And naturally enough, that means a diver carries on a trade for the purpose of ITEPA. And that is important when it comes to looking at section 4, which is the definition that my learned friend is relying on so heavily.
Just before you leave section 15, subsection 2, could you tell me what the word, what meaning is to be attached to the word instead, which appears in that subsection?
The word instead is the language that affects the deeming because it tells us that we are to replace the employment duties with trade. And it is that that fits the deeming provision into all of the provisions that relate to trade. And we see that in part 2 of ITOIA, which is behind tab 10. The general charge to tax is on trade profits. That is the charging provision. It is not, as Lord Justice Lewison said, section 15 that imposes a charge to tax. It is a consequence of the deeming language. It's because it's instead treated as a trade that we know that the income tax provisions relating to trade are engaged. I'm sorry, I didn't hear that. No. Still not hearing it.
What does it add to the words treated as a trade?
The word instead, I think, emphasizes that it is replacing the concept that is treated as a trade, in other words, the duties of employment. So if one looks at the trade hold decision in the South African Supreme Court of Appeal, there the court said that the words treated as is another form of expression of deeming. And this emphasizes that it is not the one, it is clearly the other. And it is perhaps similar to the expression as if in the predecessor legislation. So the employment is treated as if it were a trade. Replace employment with trade. Again, if we look at section 4 of ITEPA, which is on page 205 of the new bundle, after tab 7. Again, it is important to put that into context. And the context is the statutory scheme relating to divers. We're not talking about anybody else who may be governed by a different statutory scheme. And therefore, the statutory scheme is not section 4 with the definition of employment and section 7, which explains what employment income is. The context of this and the provisions that we need to look at together are section 15 and section 6 sub 5 of ITEPA, and indeed the definition of employment. And again, perhaps this raises some questions around the rewrite, because section 4 originates in this legislation. It was not found in the predecessor legislation. So perhaps the authors thought that it might be useful to include it, but one does have to look at it and say, well, really, what does it mean? And in particular, if we look at 4.1c, it includes, in particular, any employment, rather 4.1a, any employment under a contract of service. And it may well be that the others are more helpful because, again, looking at boundary issues, you might say that employment in the service of the Crown may be an office, and there may be a debate about that one, and similarly in relation to apprenticeship. But there isn't really such a debate in relation to employment. But if we put this into the statutory scheme, then our first submission is that it simply does not apply to a diver, because section 4 is subject to the general deeming for income tax purposes in section 15 of ITOIA, and therefore it simply has no application. If one wanted to view it somewhat more narrowly, then you might say, well, what kind of employment are we talking about? It's clearly not just the possession of an employment contract. There must be employment, and employment presupposes an obligation to do something, to carry out the duties of employment. And the employment that HMRC are relying on is an employment which is shorn of duties. It also has income which is disregarded when it comes to the taxing of employment income. And that would seem to be anomalous, we would submit, for that bare shell of employment to have any meaning at all. It has no significance for income tax purposes because a diver carries on a trade. So section 4, taken in isolation, might instantly make one think that that is an easy answer. In fact, it doesn't provide an answer at all. And this is supported, I think, by what Lord Walker said in the Pirelli case, where the House of Lords was looking to understand the meaning of the term tax credit in the tax treaty between the United States and the United Kingdom. That is behind tab 22, and it starts at page 383. And the comment by Lord Walker is found at page 413 in Simon's tax cases. At the top of the page, it's page 578. And what he says at paragraph 103, in differing from both the High Court and the Court of Appeal, he said that they did not give weight to two factors. One is that in applying DTAs, it's necessary to look not only to their terms, but also to the language of section 788 sub 3. Now that is the predecessor to section 6 of TIOPA. And that is the link between the treaty and the statutory instrument. So one has to have regard to that, the provisions that relieve double taxation. The other, and this is relevant in the domestic context in construing section 15, section 6 sub 5 and section 4 of ITEPA. The other is that the clear scheme of the 1988 Act is that the payment of a dividend should be accompanied by payment of ACT if a tax credit comes into existence. And about 3 lines down, he goes on to say sections 247 sub 2 does not directly affect the meaning of tax credit, but it does, to my mind, affect the meaning of qualifying distribution. The dividend paid under GIE in terms is excluded from section 14 sub 1, and section 231 is in terms made to that to take effect subject to section 241. And what that tells you is that you've got to look not just at a definition, but actually the whole of the relevant statutory scheme. And the relevant statutory scheme is as described. Now, in the Pirelli case, there was a definition, and this is mentioned in the speech of Lord Scott, which starts at the bottom of page 403. Paragraph 65, the expression tax credit is defined in the 1988 as a tax credit under section 231. And the same wording is found in section 788 sub 3. So in that case, clearly there was a definition which provided a link, but it wasn't the definition that really answered the question of meaning. It was looking at the statutory scheme as a whole for the taxation of distributions. And that is why Lord Walker says, if we go back to page 413, paragraph 4, these processes of exclusion and subjection, in other words, the tax credit provisions that said what is included and excluded, are no doubt not strictly a matter of definition, but they are a fundamental element of how a tax credit under section 247 was intended to work under the imputation system. And I submit that that is exactly what is needed in relation to the construction of these provisions. They provide the meaning because they are fundamental elements of how the deeming provision was intended to work as set out in both the predecessor and the current legislation. If one looks at section 4 again, I apologize for taking you backwards and forwards in looking at it, but the opening words say that the definition applies for the income tax parts. And that suggests, again, it is of limited application, and that the broader effect of section 15 is actually the operative provision here. in addition to that, it says that employment includes these items.
I think you meant to say that section 4 looks to the employment income parts, not just the income part.
To the employment income parts.
Yes, thank you.
Lord, I'm sorry that I am so tongue-tied this afternoon. Employment in the employment income parts includes in particular. What it doesn't say is what is excluded. And there is also nothing in this that suggests that anything in particular should be excluded. But it's quite clear from the statutory scheme again that insofar as divers within section 15 is concerned, that they are excluded. And in relation to section 6 sub 5, it tells us what is excluded from the charge to income tax. But again, because that is consequential, I submit that what should really determine is not what is excluded, but what is included in the meaning of trade by section 15. That is what should determine what is taxed, not what is not taxed. And as a result, a diver either carries on a trade or an employment. It can't be both at the same time. There is no halfway house. They are mutually exclusive, and I think that that is common ground. And the natural and inevitable consequence of the deeming provision is that the choice is in favor of carrying on trade and not carrying on employment. And that is supported by the fact that employment, shorn of its duties, and indeed with receipts that are ignored for employment tax purposes, would be a totally barren meaning of employment in the case of divers. And so it has no consequence as far as ITEPA is concerned. And that is consistent, again, with the purpose of the provision, supports the justice of the conclusion. There is no anomaly or absurdity in such a result. And in addition to that, if one looks at the other aspect of deeming provisions that were summarized in the DCC Holdings case, and this is the statement of paragraph 39 by Lord Neuberger when he was in the High Court, at paragraph 39, he says, it appears to me that The observations indicate that when considering the extent to which one can do violence to the words and whether one can discard the ordinary meaning, one can indeed should take into account the fact that one is construing a deeming provision. And my Lord, I submit that if there is violence to be done to the language of section 15 sub 2, because it requires some construction, at least to avoid my learned friend's conclusion that it is just the activity and not the employment that is deemed to be the trade. The interpretation that treats a driver as carrying on a trade is the one that does less violence to the words than the alternative posited by HMRC and Lord Justice Lewison, because they say that section 15.2 tells you how a diver is to be taxed. But that is such a broad and amorphous statement that it doesn't really explain anything at all. How a diver is taxed is actually a consequence of the deeming. It is not the deeming itself. And the dichotomy between what is taxed and how is taxed doesn't really help to explain this provision at all. The issue in this case is to work out what is the source of the remuneration or the receipt from a diver in these circumstances. And then the question as to what is taxed is answered by the relevant part of the Income Tax Act. In other words, it is part 2 of ITOIA and not the income tax parts of ITEPA. I have set out some of the other criticisms in my written case, my Lord, but that essentially sums up the interpretation of the statutory scheme, except for one element, and that is how this connects with the treaties. And the diver within section 15 carries on a trade for the purposes of TIOPA. And this engages section 6, which is found at page 232 of the new bundle behind tab 12. Section 6 sub 2, double taxation arrangements have effect in relation to income tax so far as they provide for relief from income tax or corporation tax for taxing the income of non-UK resident persons that arises from sources in the United Kingdom. And so that provides the necessary link. And of course, at least as a matter of domestic law, under the statutory instrument, a diver carries on a trade and by extension carries on business. And so as a matter of domestic law, if one's looking at the rights, then that is a complete answer. And I think that that explains the reason why Lord Justice Henderson didn't feel it necessary to go into the application of Article 3.2 of the treaty, although he recognized one of the essential purposes of Article 3.2 is to link the relevant taxing provisions with the corresponding relieving provisions in the treaty. And in the case of trade profits, it is Article 7. So those are my submissions on the domestic law. And if you have questions, then I'm happy to deal with them now. Otherwise, perhaps proceed to deal with the treaty itself.
I'm happy that you proceed to go to the treaty unless any of my colleagues wish to ask anything. No, please proceed.
Thank you, Lord Hodge. This is a matter of some importance, my Lord, and I apologize for the length of our written case on this. There are a couple of reasons. The one is that this is only the second case involving a tax treaty that has engaged the Supreme Court. And indeed, in the 21st century, the House of Lords only looked at tax treaties twice. And a number of fundamental issues are raised. And it is important that you are equipped with a good understanding of all of the issues in order to deal with it. And indeed, since every jurisdiction today looks at what other countries' courts are deciding in relation to treaties, there will be interest that will go beyond not only the treatment of Mr. Fowler, but the interpretation of treaties generally, particularly as they apply to the OECD model. If I can start perhaps with the principles of treaty interpretation, my learned friend relied entirely on the Smallwood case for an explanation of that. And at one level, I certainly have no disagreement with that at all. But that decision from 2009, I think, is looking a little bit dated in some respects. And particularly, I think, in light of the Anson decision, which places the principles of treaty interpretation squarely within Articles 31, 1 and 32 of the Vienna Convention on the Law of Treaties. I think that there is a reason for this, my Lord. If one looks at the antecedents to the Commerce Bank statements of Lord Justice Mummery, which have been described as a useful summary, both in Smallwood and in Ben Nevis, it does relate from a time when the Vienna Convention on the Law of Treaties was relatively new. And what I think Anson tells us is that what we really should be doing is looking at the language of the Vienna Convention rather than glosses, particularly where they may be based on somewhat older expressions of customary international law, which of course it codifies. So this is a more modern approach to treaty interpretation, as set out in paragraph 54 of the Anson case. And I won't take you to that because it simply says that it is common that even in the case of countries that have not signed the convention, it is applicable because it is a codification of customary international law. And as my learned friend said, the two principles that are engaged are Article 31.1. The Vienna Convention is in the second bundle, I think. Is it? No.
Are you looking for tab 13?
Oh, thank you very much, Lady Arden. Thank you. The principles are at page 234. So Article 31 is the general rule. The treaty shall be interpreted in good faith in accordance with the ordinary meaning of terms given to the treaty in their context in light of its object and purpose. And the other general rule which is of interest to us is that a special meaning shall be given to a term if it is established that the parties so intended, and that is in Article 31 sub 4. And Article 3 sub 2 of the South Africa-UK Treaty is a reflection of exactly that principle, that a special meaning is to be given if the parties so intended. And Article 3 sub 2 actually sets out the circumstances in which the parties do so intend. And I have set out detailed submissions on Article 3 sub 2 in our printed case, which start at page 69 and go over to page 70 of the core bundle. And the reason for this is that although there are a number of cases around the world in which Article 3.2 has been applied or not applied, it has never really been subject to a detailed analysis. And there are features of this case which really require us to look at that provision in some detail. And so if we could look at Article 3 sub 2, which is in the first bundle, tab 1, and it's on page 166. As regards the application of the provisions of this convention at any time by a contracting state, any term not defined therein shall, unless the context requires otherwise, have the meaning at that time under the law of that state for the purposes of the taxes to which this convention applies. Any meaning under applicable tax laws of that state prevailing over a meaning given to the term under the other laws of that state. And some parts of it are relatively easy to dispose of. It is common ground that the relevant terms, business, enterprise, and employment are not defined in the treaty. Secondly, Article 3.2 says that any term shall have the meaning that it has under domestic tax law. In other words, it is mandatory to use the domestic law meaning unless the context requires otherwise, and I will deal with that expression later on. Where Article 3.2 applies, then the meaning is obtained by the relevant statutory scheme. I've already referred to you to the Pirelli case, and this draws out, in a sense, the fact, firstly, that it is not necessary for a definition to exist. But what is important is to look at the relevant scheme to provide meaning, and that is because the treaty is absolutely clear. Firstly, meaning and definition are not synonymous, and the terms are both used. So a difference between the two is clearly intended. It's only in exceptional cases that the domestic law meaning is excluded. And we referred to the case Hammonds and Jones in the Court of Appeal, which involves the construction of a partnership deed. Now, my learned friend referred to the reasons why Mr. Justice Marcus Smith rejected this as a useful explanation of the term. That is completely unjustified for several reasons. The first is that his explanation that treaty interpretation is not to be guided by technical provisions of English law is simply inapt. This is a question of construction of contracts. It is not a technical rule. Secondly, this expression, unless the context requires otherwise, is used in many, many circumstances. It's often found in definition provisions in legislation and in contracts. And one should also not lose sight of the fact that a treaty is a species of contract. It is a contract between states governed by international law, but it is nonetheless a contract, and the principles of international law on which the Vienna Convention is based include general principles of law of civilized nations. So there's absolutely no reason to exclude this. And again, this is a provision which is often found but seldom interpreted. And this is actually the only case that I have been able to find in which a court has been prepared to say, what does this language actually mean? So if we could just look at tab 17, if you don't mind. It starts at page 306. And the relevant passage is at page 313, paragraph 32 at the bottom of the page. It's really just the last 3 lines. The definitions in the partnership deed apply unless the context requires otherwise. This does enable the definition to give way to the context if necessary. Accept Mr. Croxford's point that it must be necessary rather than merely sensible or reasonable. Now, whether one wants to play with those words or not, the reality is that the words of exception, including the word shall, taken together, are of considerable force. And they do require a compelling context for the domestic law meaning to give way. And the example that I have given is where the domestic law definition would render a treaty provision incapable of application at all. I won't take you to the excellent case, but that is exactly what it says. And ironically, if one takes the HMRC view of the construction of section 15 sub 2, that would actually render Article 15 of the treaty incapable of application, because it would mean that this trade that they say exists stranded in isolation, in other words, merely the activities that are carried on, would mean that Article 14 would not be able to apply, because there would never be any duties undertaken in the source state. So even if Article 14 applied, it would not permit the source state, in this case the United Kingdom, to tax. So that would be an absurd result. Not sure whether it's necessary to take you through Article 14 to emphasize that. And the submissions that my learned friend has made around the context requiring otherwise don't even suggest that domestic law should be disapplied, let alone meeting any sort of criteria that this language in the treaty suggests. And even if one were to adopt the language that the upper tribunal did as to the meaning of unless the context requires otherwise, in other words, that it is sensible or reasonable, HMRC's submissions do not reach that level either. So the autonomous meaning of employment and the autonomous meaning of business and enterprise are simply not engaged. And it's for good reason that neither parties have made any submissions as to what they might mean as far as the autonomous meaning is concerned. So if we look at the application of Article 3 sub 2 to these undefined terms, what do they mean? Firstly, it is clear and it's common ground that under UK law, the term business for income tax includes trades, professions, vocations, and investment. At paragraph 51 of our printed case, I've set out what Mr. Justice Park said in that case. There's nothing more to be learned by taking you to the reference, so I won't, but I think that it is clear, and indeed Lord Justice Lewison at paragraph 30 of his judgment in the Court of Appeal concurs with that. Secondly, there is no distinction between an actual trade and a deemed trade for income tax purposes. There are no provisions in the Income Tax Acts that deal with divers other than the provisions that you have been referred to. And certainly HMRC has not referred to any. And what that tells us is that an actual trade and a deemed trade is to be treated exactly the same, and it is therefore included in the meaning of business. And it is no different from the other deemed trades that we see in ITOIA sections 9 to 12 that we took you to. So the consequence is that the relevant activities which are deemed to be a trade are business within Article 3.1g, and because business enterprise refers to business, the profits are the profits of an enterprise, and a diver is an enterprise of a contracting state within Article 7 sub 1. So if I can take you to the provisions of the treaty just to make that abundantly clear, this is tab 1. And the general definitions on page 165. So again, the term business includes the performance of professional services. G, this is really the operative one. The term enterprise applies to the carrying on of any business. So the term business, which has the meaning including trades, also applies to a business. And then under H, an enterprise of a contracting state is an enterprise carried on by a resident. Mr. Fowler, a resident of South Africa, is an enterprise of that contracting state. And if we turn to Article 7, at the bottom of page 168, the profits of an enterprise of a contracting state shall be taxable only in that state, unless the enterprise carries on business in the other contracting state. So that is what brings the deemed trade of a diver into Article 7. And it is common ground that employment and trade are mutually exclusive. I think it's also common ground that employment and business are mutually exclusive. In taking you through the provisions earlier this morning, when my learned friend was talking about Article 7 sub 7, he told you that there was no overlap between business profits within Article 7 and employment in Article 14. And that must be right if we look at Article 7 sub 6, which is on page 169. It says where profits include items of income or capital which are dealt with separately, then the provisions of those articles shall not be affected by the provisions of this article. The word profit there refers to profits of an enterprise in Article 1, and it's repeated again in the other sub-provisions which deal with the attribution of profits in Article 7 sub 2 and in the rules relating to expenses in Article 7 sub 3, all refer to profits. They must all be referring to the same profits, the business profits. So the two are completely exclusive, and therefore it cannot be an employment. And so the exclusion of the diver from employment for income tax purposes by Section 15 also means that the diver does not have an employment within Article 14. Another important consequence of this is that Section 4 of ITEPA cannot be the relevant meaning that Article 3 sub 2 supplies to the undefined term in the treaty. Now, it may well be for other people that that is the definition, because there would be no conflict between the deemed and the actual. But we're only dealing with divers, so what concerns other people or other activities is not really an issue in this case. So Article 4 does not supply a meaning to Article 14.
Are you going to deal with the point about the pension?
Yes, I will indeed.
When you're ready. Don't take.
Perhaps if I can just finish off quickly this point, and that is this really comes back to the effect of deeming provisions and whether there is any injustice or absurdity. And what we say, which is in paragraph 56 of our case, is that classification of the diving activity as the carrying on of a business accords with the scheme of the domestic legislation by aligning the scheme for taxing divers as trade with the treaty scheme for dealing with such income under Article 7, which is business profits. The two are aligned with each other.
When you're dealing with questions of injustice and absurdity, I wonder if you could help me in this regard. Lord Briggs raised with Mr. Nobat before lunch the question whether what would happen under the double taxation treaty if one contracting state treated an activity as trade and another treated it as employment. And the revenue's position was that the diver working in the UK continental shelf, if he was resident in South Africa, escaped tax in both jurisdictions. Is that correct?
I don't think so, my lord. Before I answer that question, can I just finish off the point about the alignment of the domestic taxing provisions with the treaty?
Certainly, but you were talking about the question of absurdity. As long as you cover it, as long as my job is to make sure you've been given a chance to address an assertion that has been made. Thank
Absolutely,
you.
and I do intend to deal with it, my lord. I don't think that it is an issue at all, but
Thank you.
And I will deal with it immediately after this. But perhaps if we can just look at the fact that Article 7 sub 2, as I mentioned, which is on page 169, deals with the attribution of profits. So that sets out the mechanism for working how much profit is taxable in the UK. And that actually aligns with the territorial scope of ITOIA in relation to trade in section 6. So if you don't mind jumping to tab 10 again, page 220. The profits arising to a non-resident are chargeable only if they arise from a trade carried on wholly in the UK, or in the case of a trade carried on partly in the UK, where for the part that is carried on in the UK. So that is section 6 and Article 7 sub 2 then become aligned with each other. Article 7 sub 3 deals with deductions, and it says, this is page 169, setting out the rules of the treaty. There shall be allowed as deductions expenses which are incurred for the purposes of the permanent establishment. So only those that relate to the trade carried on in the UK, including executive and general administrative expenses so incurred, whether in the contracting state in which the permanent establishment is situated or otherwise. So the rules for deduction of trade expenses align with that. And that is the consistency that is provided. If I can then deal with the questions this morning around the question fiscal evasion and whether there is tax payable in South Africa or not. Firstly, it's not agreed what the position is that HMRC states. There is no evidence on this issue that has been before the tribunal. And there is also no evidence on the South African law on this subject. And as far as the treaty is concerned,
can I just intervene a moment? Lord Briggs speaking. My question wasn't so much aimed at a guesswork as to what South African tax law might provide in terms of its substantive provisions about trade versus employment. It was more geared to the effect upon South Africa of the provisions of the same treaty and the improbability that there was a provision in South Africa that treated divers carrying on their activity on the UK continental shelf as traders rather than employees. Because even if South African tax law treated them as traders, they would be obliged to recognize, wouldn't they, in accordance with their tax law, Article 14.
My Lord, this is perhaps asking a question which is the same as the anomaly that HMRC allege exists in their grounds of appeal. It's paragraph 9, which at page 21. No, it's not page 21. If you give me 1 second, I will find it in. The proposition is this, that a UK resident diver works in the other contracting state, South Africa. Is that it? Or is it the impact of this on South African tax if we apply the domestic meaning in the UK?
Absolutely. I'm assuming we have Mr. Fowler, who is diving in the UK, though resident in South Africa.
Right.
And in deciding whether they could tax him under Articles 7 or 14, they would apply their own meaning of employment. And it would, on the face of it, seem to be unlikely that they would have a provision like Section 15, not least because Section 15 is about activities on the UK rather than the South African continental shelf.
So this is a very good question, because I think it does bring into focus the way in which double tax treaties work. And it might be useful just to sketch that out very quickly. So the first step would be to decide which state the taxpayer is resident in. That's under Article 4 on page 166. And we know that is South Africa. We then turn to what I've called in our written case the distributive articles. The name was coined by Professor Vogel in his famous book on tax treaties, because those are the provisions that distribute the taxing rights between the two states. So in our case, it's Article 7 or 14. And once we've decided which article we're applying, which is for you to decide, we then look at the allocation rules in those articles. And that will determine whether the UK is entitled to tax the income or not.
I don't think that any of that is in dispute. The point that we have to decide is, at one level, the extent of the deeming provision. And what we're trying to explore with you is whether, if one extends the deeming provision to the extent that the taxpayer submits, we give rise to a situation where a charge to tax can fall between two stools. It's not chargeable in the UK because the UK treats it as a trade, and it's not chargeable in another contracting state because that contracting state treats the circumstances of the diver in the United Kingdom as the conduct of the duties of employment. That's why I was wondering what your position was on taxation in South Africa, and I understand you're saying that there's been no evidence on it, so it's not an agreed position. You're not making a submission whether or not the revenue is correct. It's simply you're taking a stance that this hasn't been explored.
The question as to whether it is taxable is not really an issue that is before us. If I can finish off my answer.
Is my summary, with respect, is my summary correct? That what you're saying is that the position hasn't been agreed and there's been no evidence on the matter, and you want to leave it at that?
Certainly on South African tax, if I can answer Lord Briggs's question, and then I'll come to the point that that you raise as well.
I don't think they're seeking, I think they're both relating to the same basic problem. Thank you.
They are. So if you decide that South Africa, that the United Kingdom is entitled to tax, or if Mr. Fowler had a permanent establishment in the UK, then that would engage Article 21 of the treaty, which is on page 176. And Article 21 sub 1 says, subject to the provisions of the law of South Africa regarding the deduction from tax payable in South Africa of tax payable in a country other than South Africa, United Kingdom tax paid by residents of South Africa in respect of income taxable in the United Kingdom in accordance with the provisions of this convention shall be deducted from the taxes due according to South African fiscal law. And so what that is saying is that if the UK levies tax, then South Africa must relieve any resulting double taxation by allowing the UK tax to be offset against the South African liability. So what it does is it shifts the tax collected, if you like, from South Africa, which would be the case if the United Kingdom could not tax, then it would be South Africa taxing alone. If the UK taxes, the money is paid to HMRC, but it is creditable against the South African tax, and therefore that would reduce or eliminate the liability to tax in South Africa. And apologies, Lord Briggs. Sorry, I can't hear.
My question simply, can you hear me?
Yes, I can now.
Good. I understand how Article 21 works, where there is a risk of double taxation. And my concern is whether there's any comparable provision in the treaty to deal with a situation where, because of the treaty, rather than for any other reason, the person isn't taxable in either jurisdiction.
Well, that may arise, and before dealing with that in more detail, if I can just refer to the language of Article 21(1) again, because it says that it must be, the credit is for United Kingdom tax paid by residents of South Africa in respect of income taxable in the United Kingdom in accordance with the provisions of this convention. And that language, in accordance with the provisions of this convention, means that if the treaty properly interpreted, including the application of Article 3 sub 2, allows the United Kingdom to tax, then South Africa must give credit. The question of credit, of course, will not arise if the United Kingdom is not permitted to tax because the allocation provision in question gives exclusive taxing rights to the resident state, South Africa. There's obviously no obligation to credit. Now, the other question that both of you asked is it possible that circumstances could arise where neither tax levies, I'll say that again, when neither state levies tax? And the answer to that, I think, is yes. And the answer to that lies by looking at the distributive articles themselves. Because what these articles do is they allocate the right to tax, but not an obligation to tax. So if we take Article 7, for example, which we've been looking at page 168, the profits of an enterprise of a contracting state shall be taxable only in that state unless. So that permits only the resident state to tax. If for some reason they don't, it simply means that the possibility of double taxation doesn't arise, but it's not that the treaty is rendered inoperable. As far as the other state is concerned, it says, if, on the next page, the enterprise carries on business as aforesaid, in other words, through a permanent establishment, the profits of the enterprise may be taxed in that other state. In other words, the resident state is permitted, but not obliged to tax. Now, that kind of scenario can come up in all sorts of situations where there are differences in tax policy between the two contracting states. And those differences are completely unconnected with the treaty itself and with the application of Article 3 sub 2. So to give you an example, the United Kingdom for a long time, as a general rule, did not impose tax on capital gains realized by non-residents. As a matter of domestic law, there was no tax. So, for example, the law has now changed on this very recently, but certainly at the time the treaty was concluded, if a South African owned property in the UK, then and sold that, then the UK and its domestic law would not levy tax on that gain. If we look at the capital gains article, which is paragraph 173, page 173, at the top of the page, Article 13 sub 1 says gains derived by a resident of a contracting state, so a South African resident, from the alienation of immovable property situated in the other contracting state, the United Kingdom, may be taxed in that other state. So the treaty permits the United Kingdom to tax the gain, but in fact the United Kingdom does not. Lady Black.
I just put it slightly differently. What I think what my lords have been asking you arises from the way in which we are interpreting the treaty, rather than the way in which the policy of the state is determined. So that by taking a rather specialized interpretation of what employment is and what falls within each of the articles, which may well not be reflected in the South African way of approaching the categorization of the income, it may result in no tax being paid at all. Now, that's not a policy decision. That is a consequence of the way in which the treaty is being interpreted. That's why I think it's being suggested to you that this may, your suggested construction may be producing an anomalous result.
Well, the opposite is also true. So if South Africa decided that they did not tax the gain, so again, historically, South Africa did not tax capital gains at all and only introduced a tax on capital gains recently. So if we had a gain which could be taxed in the UK, but which the treaty on any interpretation prevented the UK from taxing, that would not have been taxed in South Africa because South Africa just did not tax those gains. That would not render the distributive article inoperable merely because the other state does not exercise its taxing right. And I think what I'm trying to explain to you by using the capital gains article is that this is not an issue which is peculiar to proper construction of the treaty by reference to Article 3 sub 2, but it can apply in every situation where one state is excluded from taxing by operation of the treaty, and the other state does not exercise that right. And the way that this is addressed, where this is a concern for contracting states, is to include specific language to that effect. And normally what it will say is that the relief in the source state is only available if that item is subject to tax in the resident state. And that particular provision, and the difference between that and the situation that we're talking about, was canvassed a few years ago by the First Tier Tribunal in a case called Weiser, W-E-I-S-E-R, which dealt with precisely that situation. The treaty pensions article prevented the UK from taxing pensions received by an Israeli resident, identical language to the language that we have in this treaty. Mr. Weiser enjoyed an exemption from tax in Israel, and the First Tier Tribunal correctly concluded that the provision which said that the relief is only available if the pension is subject to tax in Israel meant that the UK did not have to give the relief. So it does require a special provision in order to for that situation not to arise. And it's also important, I think, to distinguish between the situation that we're talking about here and the question that Lord Hodge rather asked about fiscal evasion. Sorry, Lord Briggs, was that your question?
I think it was both of us, really.
I think, yeah, I think it was, and I think that is a separate question from this, because this is not tax avoidance, but rather the natural consequence of the way in which treaties that are currently patterned on the OECD model, certainly in this variety, are based. And if one perhaps turns to the subject of what the OECD calls improper use of treaties, which is the subject of avoidance, that is not engaged in this case, and so we don't really have material to address it. The only thing that I can offer you in terms of material is if we look at the commentary, OECD commentary to Article 15 of the model treaty, which is behind tab 36. It starts at page 714. I still need to come on to my submissions on this, but the topic that my learned friend raises is connected with this, because the amendments to the treaty in 2010 that he referred to are connected with it. But if I can refer you just to page 727. Paragraph 8.9 mentions, in the context of the general discussion around manipulation of the treaty, 8.9, the various approaches that are available to states that want to deal with such abusive cases as are discussed in the section improper use of the convention in the commentary in Article 1. So the OECD commentary to Article 1 sets out its own discussion on what it regards as improper use of the treaty. And in that, it makes a number of recommendations for provisions that may be included in treaties that do not feature in the model for states that wish to address those particular circumstances. And the subject to tax requirement, which I mentioned to Lady Black, is on that list. And indeed, it is a recommendation of the EU Commission now that all treaties should include a subject to tax provision. But the consequence of the fact that they don't is that the circumstance that I've described is a possibility.
Just to say, we better not distract you any further from your submissions. You've got about 10 minutes to go, allowing for the extra 10 minutes I've added on. Your submissions.
Indeed, my lord. I mean, as with all of these, this does take some time to explain. I think it's also important to note that the question of abuse or improper use of the convention is not something that is raised in this case. It's not part of HMRC's.
That is correct. We can read up if necessary about what applies to the abuse of the convention, because it's not directly relevant to the submissions today. Thank you.
And I'd like to just make one final point on this, if I may, just finish off on the risk of running out of time. And that is, the Lord Briggs, I think, referred to the dual purpose of the treaty in avoiding double taxation and preventing fiscal evasion. Preventing double taxation is addressed by the provisions that we've discussed today. Preventing fiscal evasion, which is essentially fraud, is addressed by different articles. That is Article 25, the exchange of information provision, which is on page 178 of the bundle. And Article 25A, assistance in collection of taxes.
Thank you.
So we were talking about the fact that the classification of the diving activity as business accords with the domestic scheme of the legislation by aligning the statutory scheme for taxing divers with the treaty scheme for permitting or preventing the taxation of income. Page 72 of the core bundle, I have set out in some detail the context, purpose of Article 3 sub 2, and divided that into the internal context, which comprises two elements. The first is a whole range of different categories of personal income, each of which has different treatment. And the only question is to decide which is the relevant item of income that it falls into. Secondly, the fact that some of the articles, the distributive articles, do have their own definitions. So there is a definition, for example, of interest and royalties, and it points to the fact that domestic meaning under Article 3 sub 2 is mandated by the context. And lastly, the context, which is the contemporary background to the treaty. Again, I won't take you to paragraph 58 of Anson, but there the Supreme Court confirms that the contemporary background of a treaty, in other words, the legal framework in which it is being concluded, is part of its context. And we say that these provisions have been around for nearly 25 years before the treaty, and therefore it is a part of the context to take into account. The important point also to bear in mind about Article 3 sub 2, so its purpose is to align the domestic charging provisions with the relieving provisions of the treaty. But in addition to that, one does have to ask the question, and I realize that it has raised some difficult issues that you've asked about, but the whole point of Article 3.2 is that the meaning of terms under domestic tax law may differ from their ordinary meaning. If they didn't depart from ordinary meaning, and if there was no propensity of legislators, particularly in the tax field, to deem one thing to be what it isn't for tax purposes, then there really wouldn't be much of a role for Article 3.2 at all. It is there, and I'm sure that Lady Arden will know from her other treaty practice that this is a very unusual provision. It appears in all tax treaties, but not in other forms of treaties, reference to domestic law meaning. And the reason for it is because in tax law, there are differences between ordinary meaning and deem meaning in tax legislation, and this is what actually aligns the treaty with the domestic law. It prevents the kind of dislocation between the domestic rules under Itoya and the treaty of the kind that we say exists. The only relevant supplementary material on this subject is found in the commentary to Article 3 sub 2 on the meaning of business and on the meaning of enterprise. Because of the time, I won't take you to those, but both of them say that the meaning of business should be determined under Article 3 sub 2. And if one looks at the commentary on the meaning of enterprise, it says that that has always been the case, that contracting states have dealt with that as a matter of domestic law. And the history of the commentary on Article 3.2, which is at the end of that part at tab 32, confirms that that has always been the case. I have set out the errors that we see both in the revenues case and that of Lord Justice Lewison, but I think that in the time, perhaps what I should do is just talk about the OECD reliance on the commentary. Apologies, my lord. I didn't actually hear any of what you said, other than I'm sure you were telling me about the time.
Sorry, I'll do it again. I was trying to explain to you. Can you hear me now?
Yes.
Yes, I was trying to explain to you that you've only got 2 minutes left. And what I was saying is you can rest assured that anything you've written in your case will be analysed and taken into account in our deliberations. But I really have to ask you now to sum up. Thank you.
Thank you, my lord. In summing up, I would firstly ask a question which has never really been addressed by HMRC at any stage before the tribunals or the Court of Appeal, and that is, for what purpose is a diver an employee? Because it is only this hollow shell that is left as a result, even on their interpretation of the deeming process. And they are inviting you to accept an interpretation of employment that is entirely devoid of meaning for income tax purposes. Their interpretation and that of the upper tribunal, as well as Lord Justice Lewison, is contrary to the purpose of Article 3.2 in aligning the domestic charging provisions with the treaty provisions. And this is the reason that we say that the arguments go against the grain of the legislation and the treaty. And the violence done to the words are simply not justified because they frustrate the operation of the provision rather than support it. And if you don't mind, can I please take you back just to one submission that I'd like to make on Itoya, and that is that if it was intended that this should just be a computational provision, then the drafters of the legislation would have used language such as we see in section 12 of ITOIA, which is found on page 222 of the new bundle behind tab 10. Section 12 sub 1 says profits and losses arising out of land in the case of a concern to which this section applies are calculated as if the concern were a trade. That is the language that would support the expenses theory that is being run. It's not the only example of that kind of language. The other one that we have is in the following tab, section 271E. Again, the profits of a property business are calculated in the same way as the profits of a trade, but it is not a trade.
Sorry, Mr. Schwartz, thank you very much for your clear submissions. I have to leave it at that. And I'll invite Mr. Norbat to give a short reply. Thank you.
Lord, can you hear me? Unfortunately, there's some BT people digging up the road outside who've just decided to start. So I hope that doesn't interfere with the reception. Well, can I take my own friend's point in turn? One of the first points he made was that the other deemed trades in ITOIA, he pointed to section 9, 10, and so on. He said that the reason for the statutory delineation in those cases is because it might be unclear how those items would be taxed, because it wouldn't be clear what the subject matter was or what was the correct categorization. And he suggested that section 15 was analogous to that. But section 15 is not analogous or similar to those cases. The legislation is not in section 15 seeking to resolve a doubtful question of whether on the facts one is dealing with a contract of service or a contract for services by making clear it is a trade. It is a precondition of the application of section 15 that there is an employment. That is why in this case it is a preliminary issue, because of course if the revenue is successful on this appeal, that question of was Mr. Fowler an employee or self-employed is still to be resolved. So section 15.2 does not resolve, and section 15 does not resolve the employment status question of divers. It proceeds on the basis that they are employees. For that reason, my learned friend's gig economy example is also irrelevant. Can I also, on the similar line, take you to the Hansard extract that he took you to? It's core volume, tab G. Page 140. And do you see, this is in paragraph 63, the quotation from Hansard. You'll see that the question to the minister is draws the distinction about self-employed for tax purposes. And the minister's second sentence says, as I have made clear on several occasions, these divers fall to be treated as employees under the existing law. So there is no suggestion that the minister was concerned that their employment status was unclear. Moreover, the minister expressly distinguishes between the employment status, which is, he states that of employee, and how the income derived from that status is taxed. And we see that from the end of the quotation. That ties in also with the fact that the Section 15 only applies to certain duties of the diver's employment, which I'll come back to. There was some discussion about the status of the Office of Tax Simplification report. In my submission, it's clear from the extract quoted in the footnote that that report was based on a review of the contemporaneous material and therefore is admissible. Significantly, the taxpayer has not pointed to any contemporaneous material or other material that suggests an alternative or different purpose. My friend sought to make a point about what is the correct focus of Article 7 and Article 14, and he submitted that the focus in Article 7 is on the exercise of the employment. In my submission, that's to construe only the tail end of Article 14 and not Article 14 as a whole. Properly construed, the first stage of construing Article 14 is there an employment? It is only if there is an employment that you then go on to look at, is there income derived from that employment? And then specifically, whether the duties of that employment are exercised in the UK. So the relevance of the exercise of the duties is focused on the location of those duties, because it's that gives the other contracting state a taxing right. Similarly, in respect of Article 7, the first point to identify is there an enterprise? And there we go into the same question about this distinction between contract of service, contract for services. My friend said that the purpose of the Section 15 was to put all divers on an equal footing, and that the justice of the result is to treat them all the same and unjust to treat them any differently. Well, clearly there is a dispute between us as to what the purpose is. We say that the purpose is limited to how the income is taxed, so that they have the benefit of the same deductibility treatment in respect of expenses. My learned friend said that the anomalies that we identify are not drawn from the real world, and he sought to explain the nature of the diving duties of a saturation diver. The difficulty with that submission is that Section 15(1)(b), and could I just ask you to turn it up, please? Tab 10, page 224. You see the Section 15(1)(b) itself contemplates that there may be other duties. That's also reflected in the predecessor provision, Section 314, which also makes it a condition of wholly or mainly. And also the tail piece of Section 314, which refers to so far as attributable to his performance of those duties. My learned friend said that a diver cannot carry on both a trade and employment at the same time. But of course, he doesn't address the position where the diver carries out duties in different locations. In those circumstances, Section 15 would treats or approaches, duties performed outside the UK are not covered by Section 15(2), and so would still, common ground, I think, fall within a contract of service, or not taxed as a trade. And that this is so, and also there's the point about if you carry out diving duties on week 1 and non-diving duties on week 2, on the learned friends analysis, in week 1 you're taxed under Itoya, or sorry, it's a trade. On week 2 it's an employment, which shows that the exclusivity that he seeks to draw isn't apparent in the legislation, and that's recognised in his printed case. Could I just ask you to turn up core volume, tab E, page 81. And paragraph 82.2, this is where he addresses paragraphs 43 to 46 of the revenues printed case, where we identify those two anomalies that I've just raised, different locations and different activities. And do you see that there the answer is not, oh, well, this is unlikely to happen. The answer that's given, if one looks in the middle of the paragraph, it is true that an employed diver would be carrying on a trade for time spent working on activities that fell within ITOIA section 15 and would therefore have to self-assess his income on that deemed trading activity under ITOIA part 2, while his employer would be required to operate PAYE on his employment income for time spent working on other activities. And the answer given is that that is precisely what Parliament requires. But what that does demonstrate is that the employment does subsist for tax purposes. In relation to section 6.5, I think my learned friend sought to suggest, well, section 6.5 is a consequence of ITOIA, but section 6.5 predated ITOIA, and the previous, prior to ITOIA, referred to section 314 of ITIPA, so the predecessor provision. In relation to section 314, my learned friend says it's clear that section 6.5 is a consequence of the deeming. But in my submission, what my learned friend has not adequately, has not addressed is the tailpiece of section 314. So that is tab 4. Tab 5. Those words, and accordingly, Schedule E shall not apply to the emoluments from the employment so far as attributable to his performance of those duties. That tailpiece would be unnecessary and indeed would not be applicable if in fact the effect of the deeming provision was to replace or supplant the employment. There would be no emoluments from the employment. Management sort of suggests that section 4 does not apply to a diver. In my submission, it's clear that section 4 does apply to a diver, and I've already addressed you on section 15.1 and the references to employment in section 15.1, which the diver must satisfy in order for section 15 to apply. And it's the section 4 definition that supplies the meaning of employment in section 15.1. My own friend sought to make something of the reference to for the employment parts in section 4 of ITIPA, but of course these are the relevant parts when defining employment in domestic tax law. I've addressed you on Pirelli already. My own friend referred to Pirelli at paragraph 103. As I say, the important point is that TIOPA itself referred to the tax credit provision, which in turn itself expressly referred to the other provision, which it was said it had to be construed with. Section 4 has no such interlinking provision or signpost. As my friend sought to make a point about Anson and suggested that in some way Smallwood was outdated. In my submission, Anson doesn't set out a more modern approach. It is entirely consistent with what the Court of Appeal said in Smallwood and what Mr. Justice Mummery said in Commerzbank. My friend's submissions about Hammond and Jones, in my submission, we simply don't accept that there is any comparison between the construction of a partnership deed and the interpretation of a treaty. Principles of treaty interpretation clearly do not apply technical rules of English law. We also don't accept that our construction of Section 15 would render Article 14 incapable of application. Section 15 on our case simply addresses how certain duties of the employment are taxed. It does not alter their essential character. The issues identified by my learned friend only arise if the deeming goes as far as he contends. That's another reason why we say the deeming doesn't go as far as he intends. In terms of his submission that Section 4 cannot apply the domestic tax law meaning for divers, even if it applies to other people, in my submission is important because he is accepting that in the vast majority of cases, Section 4 does provide the domestic tax law meaning of employment. And in my submission, Article 3.2 is not intended to operate at the level of granularity that he seeks to, that his submission would require. In that regard, in my submission, it is significant that whereas the absence of capital gains in South Africa might well be something that would be at the forefront of the drafters of the treaty's minds, in my submission, it is highly unlikely that the drafters of the treaty would have in mind what is a rather obscure provision in Section 15 relating to particular duties of saturation deep sea divers.
No bad. 1 minute.
Yes, yes, Lord Hodge. 1 minute. Okay. Can I deal very briefly with the points raised by Lord Briggs and Lord Hodge? My instructions are that as you know, the divers are one of many. Mr. Fowler is one of many divers affected by this appeal. There are other appeals behind it, and my instructions are that most divers have confirmed the position that they did not pay tax in their home country because of the foreign earnings deduction. Mr. Fowler must be in a position to confirm whether or not he paid tax in South Africa on the income arising from his UK activities. And of course, the point is that these issues don't just apply to the position in South Africa. The DTA is based on the OECD model, and so it applies more broadly. Lord Hodge, unless there's anything that I've not addressed you on that you would want me to, I hope I'm within your minute.
Thank you very much. I'll just check with my colleagues. Does anyone want to raise any final questions? No. It only remains for me to thank counsel sincerely for their cooperation in this case, which has been truly an experiment on our part. And I'm very grateful to you for your collaboration. I remember when I was in practice, I found it difficult sometimes to make submissions in front of an unresponsive judge when I was there in person and he was there or she was there in front of me. So it's been perhaps more difficult for you today, having been faced with a row of faces at the bottom of your screen, most of whom had their mute buttons on for most of the day. So thank you very much for your endurance of the way the system has worked. Thank you also to the legal teams behind counsel for preparing the papers and the wider appeal. And thank you also to the IT staff of this court for making our first remote or virtual court hearing possible. We will take your submissions away and deliberate them and produce a judgment in due course. The court is now adjourned.